Good afternoon and welcome to the December 4th edition of Success by Association Live. This issue is sponsored by Pinehurst Resort. We thank them for their steadfast support of AENC. Today's article was written by Michael W. Mitchell and Edward Roche and is reprinted with permission. The article is titled, Be Aware of Copyright Infringement When Posting Stock Photography. Hundreds of millions of photographs are posted online every day. As the U.S. Court of Appeals for the Fourth Circuit recently noted, the internet has made copying as easy as a few clicks of a button, and users frequently copy photographs for business or social purposes. When doing so, users should be aware of the risk of liability for copyright infringement. The Fourth Circuit's decision in Brammer versus Violent Hughes LLC sheds some light on when reposting will be a fair use and when it will give rise to liability. The creator of an expressive work, a photograph, video, movie, book, play, piece of music, or architectural design, owns the copyright to the work. The copyright holder has a number of exclusive rights, including the exclusive right to reproduce the work or create derivatives of the work. The holder may have a claim against anyone who copies or repurposes the work without permission. If others want to use work, the copyright holder may charge them a license fee. One exception is fair use. If the use of the work is considered fair use, there is no need to obtain the creator's permission, and the creator does not have a valid claim for copyright infringement. But as the Fourth Circuit's decision in Brammer demonstrates, whether a use is fair can be a complex question. Based on the particular facts of the case, the court ruled that the reposting of a stock photograph did not constitute fair use. The opinion gives guidance to those creating and using online photographs, but also leaves some gray areas. Background of Brammer versus Violent Hughes LLC. Brammer involved a professional photographer who licensed his photographs as stock images. He posted his photographs online and others would pay for print copies or to license the pictures to use online or in print media. In 2011, he shot a stylized image of Adams Morgan neighborhood in Washington, D.C. Taken from a rooftop at night, the picture showed moving vehicles as red and white streaks of light, creating a vibrant, colorful image. The plaintiff posted the pictures on his website and also on Flickr, a photo sharing site. Some users bought physical prints of the photographs and 2 users bought licenses to use the picture online. Without obtaining a license, the defendant copied the picture and posted it online. The defendant was a film company that ran a film and music festival in Northern Virginia. It used the picture of Adams Morgan to show festival visitors a nearby neighborhood to visit. The photographer sued for copyright infringement. The film company argued that the posting of the photograph constituted fair use. The district court agreed with the film company and therefore ruled that the company did not infringe the photographer's copyright. The photographer appealed that decision to the Fourth Circuit. The Fourth Circuit's decision. The Fourth Circuit decided that the film company's use of the photograph was not a fair use, allowing the photographer's damage claim to proceed. The court explained that the ultimate test for whether the use of a work constitutes fair use is whether the purpose of the copyright, promoting the progress of science and useful arts, are best served by allowing the use or preventing it. To help apply the nebulous standard, the FAIR statute 17 U.S.C. 107 gives court 4 factors to consider. The purpose and character of the use, including whether such is of commercial nature or is for not-profit educational purposes, the nature of the copyright work, the amount of substantiability of the proportion used in the relation of the copyright work as a whole, and the effect of the use upon the potential market for or the value of the copyrighted work. The Fourth Circuit determined that none of the 4 factors suggested fair use. The character and purpose of the film company's use of the Adams Morgan picture did not indicate fair use for 2 reasons. First, the use of the photograph was not transformative. Sometimes the reproduction of a work may give the work a new meaning or message. For example, a picture may be a necessary component of a news article or a book depicting historical events. Here, however, the photograph appeared in substantially the same form as the original. It was supposedly used for informational purposes, but the film company could have conveyed the same information without the photograph. Second, the use was for commercial purposes. Though the photograph did not directly generate revenue for the company, it was used to promote a for-profit film festival. Because the company had essentially reused the photograph in its original form for commercial purposes, the purpose and character of the copying did not weigh in favor of the fair use. The court rejected the film company's argument that the company's good faith changed the character and purpose inquiry. The court did not agree that the use was in good faith, as it was not reasonable to believe that the photograph was available for free. Regardless, the court reasoned that while bad faith may weigh against fair use, good faith does not suggest fair use. As the court explained, copyright infringement occurs even if the user does not know he or she is infringing. Believing that a work may be copied does not shed light on whether it may be copied legally. The second factor, the nature of copyrighted work, also indicated that the copying did not constitute fair use. Generally, the more creative a work, the thicker the copyright protection it receives, and the less likely that a reproduction will be a fair use. Photographs generally receive thick protection, especially when they are the result of significant creativity. The photograph at issue did not simply show what Adams Morgan looks like, it presented a stylized image that was the result of many creative choices. The third factor, the amount and substantiability of the portion used, also pointed away from fair use. Roughly half of the original picture appeared on the website. Only the negative space had been removed, keeping the most expressive features. Finally, the court explained that a use is less likely to be fair if it is, quote, unrestricted and widespread, end quote. Uses of the same type would substantially depress the market for the original. Where the use is non-transformative and for commercial purposes, as was the case here, courts presume a negative effect on the market. Widespread commercial copying would deprive other creator of licensing fees. The film company could not overcome the presumption in this case that the type of copying it engaged in would harm the market for the picture. Considering all four factors, the court determined that the unauthorized use of the photograph would not serve the purpose of copyright law. In fact, the court explained that if stock photographs could be copied for commercial purposes without expressing anything new, professional photographers would have little financial incentive to produce their work. The film company's fair use defense therefore failed, allowing the photographer to pursue his claim for copyright infringement. The case was returned to the trial court where the parties settled for an undisclosed amount. Takeaways from the Brammer decision. Photo sharing is ambiguous, and the Fourth Circuit's opinion does not predict how the fair use principle would apply to all instances of photo sharing. The court itself recognized that the decision did not express any opinion on the sharing of photographs on social media platforms, which are, quote, are specifically designed for the participatory sharing or copying of content. And while the use of stock image in Brammer was not a fair use, some of the stock images may be. The test is fact specific. The application of those four factors will be challenging. In Brammer, the trial court and the Fourth Circuit disagreed on all four. With this uncertainty comes a significant risk. A defendant found liable for copyright infringement may be required to pay the copyright owner all of the infringer's profits from the use, plus damages for any financial losses the copyright owner has sustained. If those amounts cannot be proved, or if the damages would be low, the copyright owner can request statutory damages of up to $150,000 for each work infringed. Before sharing or repurposing photographs online without permission, businesses and individuals may wish to seek legal advice. If a dispute arises, both copyright owners and content sharers would also likely benefit from legal advice to navigate the complexities of copyright law and the fair use principle. Users may also consider other steps to mitigate their risk. The safest approach is to assume that the user of a picture or other content will not be fair use and may give rise to liability, or to ask for explicit permission from the copyright owner before posting. There is no risk, of course, if sharers generate their own content or use free stock photographs. Some pictures sharing sites offers images that can be without copyright restrictions. Some sites include only free content. Others, such as Flickr, which was used in Brammer, allow owners of content to specify whether their content can be used for free or licensed for a fee. That concludes our article. We hope you have a great day.